Happy to be here today with CPA and valuation expert Tom Gillmore. Tom, welcome to this month's webinar.
Thank you for having me. Appreciate it.
And Tom and I have worked in the past together on cases where usually involving some type of business dispute where there's a question of a value. This often arises in the context of partnership breakups, business divorces, shareholder buyouts, quite frequent in the healthcare industry, but in all industries really. And today I'm going to sort of facilitate a discussion, I hope, here with the folks that are watching us today and with Tom. And without any further ado, we're going to move into today's agenda. And we have a lot of slides. Tom has provided us with a wealth of information, and you'll find that on the slides. But I'll also say that if you have any questions, please bring them to our attention. You can drop them into the chat as we're going through the program today. And there are certain issues that may come up that we spend more time on, and there are certain slides that we may just sort of not spend as much time and gloss over a little bit, either because it doesn't constitute one of the main points that we want to get across to you today, or it's something that we just don't have the time to spend on for today's topic. But you do have a wealth of information, and you're welcome to follow up with us with questions for Tom or myself, and our contact information is in the back. So with that, moving into our first topic, which is being the most informed at mediation. And this is really what this seminar is all about. When you go into any type of situation where there's a dispute, and of course mediation is a fantastic mechanism for dispute resolution, and it gives parties an opportunity to settle differences without going to court in an organized fashion through the use of facilitated mediation discussion with a third party neutral. I serve as a mediator. I represent parties in mediation and serve as a mediator and participate in these quite often. And when you go into that type of environment, you want to go in with as much information as can help you negotiate your best deal. And when you're talking about business disputes, that often involves figuring out what the value of the businesses is that's in dispute, or figuring out whatever the business interest is and the value of that interest. And as you'll see, the two are analogous, but not always exactly the same type of concepts. So with that, I'm going to sort of, ask Tom to jump in and just explain about, from his viewpoint. Tom, how do you think litigation folks and people that are in disputes can use this information to their best advantage?
Well, thanks again, Eric, for having me on board with this with the presentation today. I think one of the things to keep in mind, anytime you go into a negotiation or a contract settlement, is just to keep an open mind and realize that, and even make a statement to the other party that, I could be wrong on this point. Help me understand your point. Let me try and get a feel for where you're at on things. And, to your point about being the most informed at mediation, we try for, to be on point all the time, but we're going to miss a mark now and then. And so you just want to do the best you can to understand, first of all, the terminology that's being discussed, and get a heads up before you go to the mediation. When you get a valuation report in front of you, you want to make sure that somebody on your team understands what they're looking at. You can bring in your own appraiser, or you can have someone, an appraisal review specialist, take a look at it, and be willing to challenge something that just doesn't feel quite right. Your client thinks the practice, the healthcare practice, is worth $2 million, and the opposing party is saying it's worth $1 million, or they're saying it's worth $5 million if you're actually trying to get a lower value. A lot of people have a good idea what they're worth in the marketplace, and sometimes a person could be confused. The business owner, a lot of times you ask them, how important are you in your company? And of course they're going to want to say, I'm really important. I'm just this place wouldn't exist without me. And what they don't realize, perhaps, in that statement is that I cannot sell the practice if you're really that important. I got to have something to sell. outside of the possibility that you would stay on with a workout or an earn-out type of thing to help the transition, we need something to sell. We need the workforce in place. We need to have the patient list. The internet presence is a valuable thing that we can look to. And I'm probably jumping ahead about 12 different slides, so I'll try and back off a little bit.
That's okay. It's I think that the takeaway is figuring out the best way to gather all the information, put that information to use for your negotiation, and the concepts and the valuation concepts as they relate to businesses, both in buying and selling and in the dispute process, can be very helpful. I'll hop on. And I would add too, when we're talking about being informed, this is a good opportunity. The mediation gives you an opportunity to educate the other side as well. You can use it as an information gathering process to find out what the other side thinks are the key points. And you can also use it as an opportunity to educate the other side. So if somebody's making incredibly unreasonable demands in your view, and you have a business valuation that's done by a professional, and you provide that information to the other side, give it to them in advance and let them have that information vetted on their own. You can do it still under the confidentiality cloak of mediation, but allow them to take a look at it so that they can come in and perhaps be a little bit more informed when you finally have your session. Oh, pardon me here. Just, all right, so uses for the business valuation, obviously in a sale, whether for the entire practice or in valuing the practice for either selling a piece of it or a buyout type arrangement. And Tom, you've listed these points here. Other points that maybe aren't on the slide, or ways we can use the business valuation, particularly in the dispute resolution context. What's been your experience?
Well, yeah. In any event, you want to make sure that you have a defensible valuation in front of you. The last thing you want to do is take this thing into the courthouse, because like you've said previously, Eric, it's just a trap door waiting for either party to fall into. So, you know, there's tax strategy, tax planning that you want to get into for evaluations. We have shareholder disputes that can be settled out of court at mediation. We recently had a probate case, for example, where you know, one of the beneficiaries is looking for an extremely high value on what they can see is a highly valuable company, but what they don't realize, again, is the personal goodwill that's a component of each company. And we'll touch on that point again. But you know, what I really enjoy about the ForsterBoughman law firm is that you guys work with the grantor retained annuity trusts and the family limited partnerships. You guys get into the spousal lifetime annuity trust and some other fancy terms that people would probably want to reach out to you for as far as the planning. So, you know, not only is there the dispute component of each scenario, but you could have tax planning strategies that need to be addressed as well, including the stock appreciation rights program that we have listed here on this slide. And then it's in slide 3, we get into the premise that both parties are willing and informed. The IRS Revenue Ruling 5960, which came out in 1959, states that each person is assumed that the hypothetical buyer and hypothetical seller are both willing and that they understand the marketplace that they're operating in. And then the other premise that I wanted to mention is that from a valuation analyst standpoint, we try and determine the highest and the best use in each case. So you're even though I might be hired to find a value that's preferable to the owner, not only do I have to be unbiased in my approach to the assignment, but I'm looking for the highest and the best use.
And when we're talking about the fair market value, there's a note here at the bottom where, and I wrote this in, that a piece of the pie is often, there should be a not in there. Note that a piece of the pie is often not as proportionately valuable as the whole. And it's been my experience in working with you, Tom, and dealing with these issues again, and often in a dispute resolution context where there's maybe a minority interest. You mentioned a probate case that we worked on together recently. I've been involved in family in divorces where the business gets split up, or where kids inherit a business and there's different pieces. And especially if it's a minority interest, if it's a closely held business, it might be worth $10 million, but that doesn't mean that 25% of the business is worth 2.5 million. And that's something. Do you find that people are surprised by that in your practice when you try to explain it to folks that don't deal in this world every day?
Well, yeah, that's true. And you know what Eric's talking about here, everybody, is that the likelihood that even though we found a $10 million fair market value, if we're talking about a 25% ownership in it, we have to take a discount, more than likely for a lack of control. In particular, the minority shareholder is at a disadvantage in that it goes back to the probate case we just had. The interest, in fact, I believe it was a 50-50 ownership interest. And so there wasn't any break point for either one to be the majority shareholder or the minority. And so we had to apply a minority discount to both sides. And so the controlling shareholder obviously has the opportunity to sell the company at will, or pay theirself a salary that's beyond the reasonable, for example, and other factors. And then there's also the part about the discount for lack of liquidity, which is another component of the proportional pie piece that Eric mentioned there. So I'll give it back to you.
All right, and let's move on a little bit, and we'll take a deeper dive into the material. We started talking about this, even though the last case we worked on was not a healthcare practice. It's something that you deal with a lot, and that I deal with a lot in my practice. And that's how we started talking about this. So, this is just some statistics that you pulled out regarding deal making in healthcare. And the other point here is that not only are there a lot of deals with private equity getting into healthcare and hospital groups growing, group practices growing, where it's very difficult sometimes for small physician-owned practices or even smaller dental practices, any type of professional services. Sometimes it's hard for them to compete because of all the regulation and all the red tape and issues that they have to deal with aside from the practice. But where I see this issue come up a lot is really in the business divorce context. And I just mediated a dispute. Actually, we avoided litigation with a couple of doctors just recently that had been in business together and were separating. And understanding the value of the practice and understanding the value of each contribution is vital to working out a deal that avoids going to court. So talk about confirmation bias in general, your reputation as a valuation expert and professional, someone who has to prepare materials that are going to be vetted by the other side and getting ready potentially. I've been involved in lots of cases where we do direct and cross examinations and depositions and interviews, but you're on the other side of that. So you want to talk about that a little bit in your experience?
Yeah, well, as an expert witness, I have to be impartial, and really I'm here to assist the court, right, the trier of fact. So it might not be something that everybody's familiar with, but the judiciary is not necessarily well informed on the issues of business valuation or even a balance sheet or a financial profit loss statement. So you want to make sure that you're articulating the concepts at an understandable level. Maybe I don't want to disparage anybody, but you want to keep it at a grade school level if you can, even And we talked about being impartial, but there's confirmation bias. You know, if I send my work out for review before I submit it, in particular, if I have a case that's going to be potentially seen by the IRS or the Department of Labor, I want to make sure that someone else has looked at my report because I'm human. I'm subject to confirmation bias. Some of these reports get into the 50 or 100 pages in length. And, you know, my mind wants to see what it agrees with. So it's always good to have a second opinion. And you could, in a mediation setting, you could ask the expert witness on the other side if they have done that. Did they challenge management assumptions? Did they have a third party look at their report? You could ask them if they've ever been challenged or if their testimony has been disputed on the witness stand. So, and to that point, you want to make sure that if you are an expert witness and you're listening to this webinar, you want to make sure that you understand the case law that you're dealing with and that your attorney understands it. Sometimes, you know, if you get a young attorney who's maybe not had a business valuation case, you're really hanging yourself out there as an expert witness, because not only do you have to educate the court, you have to actually educate your attorney. And some of them, you know, are busy. They don't want to necessarily hear what you have to say. If you're bringing in some kind of a new concept in your valuation approach, you're at risk of toppling the cart. But if you believe in your position, then you want to articulate that. And to that end, you know, from my side, I've had that happen where I stood my ground, and it's become, I wrote articles on the topic, and it's become published nationally. So it's okay to stand your ground, but you do want to try and educate your attorney and all the other parties involved in the case.
And also this idea that you go into mediation, you want to go in with all of the information, you know, all the best amount of information that you can go in with. But there are ways to preserve your confidentiality of information. There are ways to best use it. So just some examples I want to point out for folks that, you know, if you're dealing with this for the first time or first couple times, or things to keep in mind. When you retain the valuation expert, if the law firm retains that expert initially as a consultant and it's not disclosed as an expert, you can keep that information off, and you can keep your any draft reports, any other information away from discovery. Whereas if the client directly retains a valuation professional to do a business valuation, that information is going to be discoverable. So we often recommend, and that's what we did in our recent case, that the law firm retain the professional to serve in a consulting role until we find out if we want to use that information. And candidly, it gives the attorney and the client an opportunity to shop around a little bit and find the best information. But if you get a valuation report that you don't like, and the client has ordered that report or dealt directly with the professional, and it's discoverable, that could be harmful to your case later. But if the attorney has it and we don't like the report for one reason or another, either because we don't like the figures in the report or we just don't think that it's defensible or for some other reason, we can often work behind the scenes to determine whether that report can be modified, that it works for everyone, where the expert still maintains credibility, but the attorneys and the parties can use it, or find a new expert, or decide we want to take a different approach. And when we're going into a mediation, what I will often do, if I'm representing a party in the mediation, then we will agree ahead of time that all the information that's exchanged, not only the communications in mediation that are always confidential by rule, but that any information that the parties exchange in advance of the mediation will be solely for mediation purposes and kept confidential. And you can go a step further if you want, if there's reasons you don't want information disclosed. Perhaps maybe the person on the other side is a potential future competitor. You may want to disclose the information where it's only the attorneys and experts who can look at it, and the mediator, to, again, help facilitate that discussion and make sure that everybody's well informed. And Tom, I take it, now there's so much background research that you can do on experts. You can find all their past testimony. And 20 years, almost 20 years ago, maybe 15 or so, I was involved in a case, and it was ironically, it was a hotel. It was a hotel buyout involving a big hotel chain. This was around 2006, and the financial expert on the other side had written a bunch of stuff, had written books, and was very well known. But a court, I think the court was in Delaware. He testified all over the country, and there was some language from a judge in one of his recent cases that basically said that the expert would come up with whatever number the parties wanted for the right price, and that was just devastating to that expert's credibility in our case. And I can't imagine that it was helpful for his career as an expert going forward. So that's, I guess, one of the hazards of getting too aggressive with an opinion that's been influenced. I'm sure you deal with that a lot. You have that experience where the attorneys or the parties are like, why is this number here? How do we change it? How do we make it bigger or smaller?
Well, right. I mean, you want to be careful about what you say in front of a judge, and you definitely don't want to, make them mad, because they will write things about you that are very disparaging and hard to overcome. Back to your point about getting different valuation results. I recently had a case where I was hired directly by the client, which is not something I suggest. I normally want to engage with the law firm, just like you said, so that we have confidentiality. Anyway, I was hired, and I told the guy, I said, you really want to just not tell anybody that you have this report, because quite honestly, the opposing expert may have a more favorable number for you, because I know the other side. I know the other expert. I know his approach to valuations, and we have a different kind of a mindset about some issues regarding goodwill. And quite honestly, I think that the client might have had a better number from the opposing side. So we'll see. We haven't got to trial or mediation on that case. But yeah, I mean, it's great to it's kind of fun to say, oh yeah, I'm an expert witness and I go to court, and but quite honestly, people like Eric are paid to shoot me down, right? Or shoot down the other side. They make good money on researching a person's background or challenging your report. And it's all in, if I just keep it for myself, I'm doing what I can for the court. I'm trying to just get the truth out there as I see it, and let the chips fall where they may.
And one of the first things I'll add that I do if I am opposing a party and they have an expert report or business valuation is I want to get that report from the other side into my own expert's hands. If I'm working with Tom, obviously, as soon as I get something, I want to get it to Tom so that he can look at it and then give some feedback. And that's going to be your best counter punch, essentially, to a valuation report from the other side. And again, the mediation process really kind of allows for a greater free flow of information because you have that cloak of confidentiality. So you have some specific points on things to look for in the report, and see challenge estimates of growth is our slide here. And what do you mean by that specifically?
Oh, I'm sorry. I was looking at the chat box from someone. So yeah, when I in the valuation process, we look at a lot of times we'll do a discounted cash flow on future, bringing to present value the management's estimate of future cash flows. So the owner of the firm and the CFO are very likely to be pretty excited about what their opportunities are going forward, and they themselves might have a confirmation bias, right? They think, we're just going to go gangbusters. We're all going to get rich. We have this great idea. And the analyst needs to look at that with some professional skepticism, challenge management on their growth projections. Do they consider the CapEx that's going to have to occur? And do they have enough working capital to pull this off? And do they have sufficient teamwork, is their team big enough? They're going to have to hire people. Do the numbers make sense in the end? So, you want to ask the analyst, what adjustments did you make? Did you just take, you'd probably say, you just assumed management's growth was accurate, didn't you? And the analyst would say, well, no, I challenged them. So you want to make sure they actually did challenge the management. And so we could go to the next slide and see.
Well, Papa, I want to hit this question too, because I want to encourage folks, and I like getting the questions. The question,
so here we are. Oh, go ahead.
What do you consider as the most important point to, what's the most important point to consider when choosing a valuation firm or a valuation expert, I'll say? And I think we could both answer that. We might have different takes on it. What would you say, Tom? What are the important points you think people should look for?
Oh, you just want to make sure that the person in the firm have the credentials. First of all, have they been trained? Not all CPAs are trained to do this kind of work. You want to know that they've had a history of testifying in court. Have they written any articles? Are they respected in the community? What percentage of their work is in this sector? Or are they a part-time valuation analyst that is available during tax time, or are they consumed by tax preparation work, for 25% of the year? And you could ask, send us an email. We'll let you know what we think about the firm that you're considering.
Yeah, sometimes getting the opinion of other experts. For my practice, I think getting opinions from other lawyers. What's important is, as you said, credentials and reputation. But another key point that I think is often overlooked is how easy is it to work with the expert? Is the expert accessible? Am I able to schedule a call or get a meeting, or is it going to take 2 weeks for me to get 15 minutes? And how well does the expert communicate information? So I years ago, there was somebody that I worked with. I think you were involved in that case, Tom. It wasn't you, but there was some complicated issues, and the person who provided the written analysis was fantastic as far as the depth and the explaining the information on paper. But when it came time to sit down and testify, it was impossible. And I realized, and I come into that situation a little bit late, so I hadn't retained that expert, but I realized that I couldn't even put this person on the stand because during an evidentiary hearing, because they just weren't going to be able to explain the information in a way where they were comfortable with it, where they could defend it, and where they were able to communicate it in layman's terms so that a judge or a jury, whoever the fact finder is going to be able to understand it. And that's, I think, often overlooked, is just how easily you work with that expert. So discount rates. This is, you put here, it's a prime area for manipulation. I know this from past experience, that small variables in the discount rate can lead to very, very big variations in value. Can you explain that a little bit more?
Right. So the big deal here with the discount rate is that the analyst will look at the subject company and make a determination about the risk of investing in that company versus the risk of other investments. And the interpolation of that is called a discount rate. You'll also hear the word capitalization rate, which is the discount rate minus growth. But getting back to the area of manipulation, I've seen reports where they're using a discount rate of, say, 23%, and there's no articulation about how they got there. I mean, as an analyst, I know that you're probably in the right range, maybe 18 to 20, 23%. But from my point of view, I want to know how you got there. And in our industry, there's a method, and they call it the build-up method, as one way to determine it. And you look at, just for example, just like any other investment, you look at the opportunity to buy treasury bills or treasury bonds. And those are usually considered to be a risk-free opportunity. There's very little risk that you're not going to get your money or not going to get your growth out of that investment. And then we add in the rate of return on a large company stock. For example, if you're in a Vanguard ETF on a large company portfolio, you would expect to have an annual rate of return of 7%. And if you're looking at the S&P 500 or small company stocks, you're looking at, you want a higher rate of return. You want maybe 10 or 15%. And so we add those numbers together and we have some reasonable, rationalization for doing that. And then we look at the subject company itself and determine how much more risky is this specific company compared to everything else we just talked about, the large company, the small company. We also want to look at the industry they're in. Is that specific industry subject to a larger beta against the norm? Do they fluctuate? Is there a higher risk in that specific industry? So, for example, during COVID, there was a lot of industries got hit, but none more probably than the restaurant industry and the entertainment, Disney, for example. So that's a one-time event that you need to consider, and how that affected the cash flows during the look back period. So,
and so let me ask, just from a layman's perspective, for clarification, I like what you said, that the discount rate essentially is analogous to the risk rate of investing in the business. So a higher discount rate is going to be something far above the risk-free rate, and that higher discount rate is going to be factored against expected future cash flows of the business and give it a higher value. Is that a fair way of explaining it? That a higher discount rate?
The lower the discount rate, the higher the value.
Higher the value, right? Inversely proportional. Pardon me.
Right. It's inversely proportional. So, if I come in with a 5 or 10% discount rate, you're going to have a much higher value than if I came in at a 20% discount rate.
I totally conflated that concept as I was explaining, but right. So
I know you understand it.
Or for a secure asset like a U.S. Treasury is going to have higher value because of the lower risk, versus a business that's got a ton of risk is going to have less value because of that increased risk.
Right. We're just trying to capture the risk we're trying to quantify it into a numerical ratio. Right. Yeah.
And so that's one of the things that I know when I get a report or I'm looking at the valuation report, one of the key pieces that I will focus in on, and I like ranges. And so when we use these things in a negotiation or in a mediation context, I often like to say, okay, what would be the extreme range, and then what's a more fair number, whether it's with something like a discount rate or some other variable, and try to get as extreme as possible that might be defensible, at least in the mediation context, right? Because we're negotiating and we're bargaining, and
Absolutely.
try to anchor. And so that when we come back to whatever number, whatever that extreme anchor is, when we come back to whatever number where we want to land, it sounds much more reasonable. And is that a fair thing to ask of you? I know, I think you and I have done work where I've asked you, can you give me kind of two scenarios, and we play off those scenarios. Would you do that with the discount rate?
Well, absolutely. And it really goes to the point of the artistry of my industry. So this is not a, we're not building a spaceship here. This is more, it's in part an artwork. So it's subject to, my opinion on things or your opinion on things. And there's always room for discussion. Again, I have to be impartial, and I can't be, not supposed to be swayed by but, for example, I finalized a report recently and sent it over. I think it was somewhere in the range of $100 million. And I had a discount on there of 33%. Well, the client was upset because of that discount rate. And so when I asked them about it, it turns out that they had information that I wasn't aware of. So, and that information had to do with whether or not they had hard offers on the company, offers to buy. And in fact, they did. So that cut my marketability discount in half. Without that information, I had them at 33% marketability discount. And when I found out some more information from them, you know, we brought it down to about 15%. So, you know, I don't believe that the appraiser should be doing that kind of thing without some really good hard conversations with why they made that change. But yes, to your point, a range is, in fact, oftentimes a report will come out with a range of results. I like to bring it into a round number. But yeah, everything's on the table within the parameters of honesty and, you know, truth-bearing material.
You make another good point there with getting additional information from a client or from the attorney. And I would recommend anybody doing this, get a draft first. Again, earlier we talked about the benefits of having the attorney hire the consultant. At that point, you're not really an expert until you're disclosed, although we consider you an expert in our, you know, inside terms. But you're not a court expert who needs to be disclosed until you're designated, so you can keep all that confidential. And then we can do draft reports and sometimes get that first draft and look at it and say, well, wait a minute, did we factor this? And so I encourage the attorney and the clients to look at that with a critical eye and then get on a call, walk through it, ask questions, and make sure we have all the information that's going to be helpful for us.
Yeah.
So more on the risk-free rate. I learned something new. I didn't know that used to be called the Citigroup Pension Liability Index. So I always thought it was just like the Fed's fund rate or the risk-free rate. Inflation analysis, that's a huge topic right now. Are you making recent adjustments because of, I've heard that inflation, we're now at a 40-year high for inflation. Are you making adjustments based on that?
I would want to add in probably a 2% inflation rate based on the 120-month outlook from the Federal Reserve Bank of Philadelphia. They don't believe it's going to be running at 8% for very long, or anything above the 2% that I just mentioned. So you want to make sure that the analyst has at least considered it in their risk profile. It can make a big difference.
And okay, Goodwill. So this is another area often confused: personal goodwill, business goodwill. It's a big topic. I think even more so in the healthcare context, where we started talking about this because of all the compliance, the regulatory compliance issues. And so if you're operating a business that's got a big compliance risk and you don't have a good, well-documented set of compliance standards, it can hurt. But walk us through some of these factors that you have here on the Goodwill, Tom.
Right. So, well, the primary thing is to differentiate between the corporate goodwill and the personal goodwill. So when it comes to the corporate goodwill is something I could sell. I could sell the patient list. I could review the phone number and website that we have mentioned here, the SEO presence, the workforce in place. You need to consider whether or not the employees are likely to stay on board, and if so, what kind of revenues are associated with that. The geographic location of a healthcare facility, or if they have multiple facilities. The phone number and the training, the like, not only in the compliance sector or compliance component of it, but the training of the employees. Do they do their CPT training annually? And I mentioned the registration with the insurance panel there, but it's kind of going off topic.
Insurance compliance and training, and then credentialing is big if you've already got a lot of that in place. If that's transferable, transferable contracts so that a buyer can come in and just take over the business. In the split up context, you also get the question of who's going to get access, how will the records be split? How will software and other things be, if you're breaking up a business versus just having one person leave. And so it's a business that's easy to slide into, to walk in and start from day one that has all these pieces. It looks like you're lining for that you lined up here for the corporate goodwill. It's just actually going to have more value.
Right, absolutely. Even
You
with the electronic record keeping is another.
Exactly, the electronic, the process and the systems that are in place for that. Privacy has become a big issue, so ensuring that there's policies in place, Medicare, Medicaid, any type of compliance with not only insurance but with government, and you had here audit triggers. If you're this is kind of an interesting point that you put in here, is if you're claiming reimbursement for a higher than usual frequency of services than other health professionals. Have you called that out in the past, or does that come from experience, or what made you put that in the slide?
I haven't had that problem, but it's just a Medicare is paying close attention to healthcare entities that are they're outside of the standard deviation. For example, if they're operating around the mean of services for a particular CPT code, there's probably no question. It's just like any other, it's like an IRS audit. If they see you're an outlier, they're going to want to drill down and figure out what you're doing and challenge you on that. So you just want to know if they had a Medicare audit and how did they survive, and whether or not, in your opinion, they're operating within guidelines.
And another issue here too is that in some businesses, like with healthcare businesses, law practices are the same. They cannot necessarily be owned by anybody. Like dental practices must be owned by a dentist. Optometry practices must be owned by optometrists. Interestingly, a medical practice can be owned by a non-physician under our corporate practice of medicine doctrine, but you still have to have a physician to serve as the medical director, and perhaps maybe the reputation and goodwill of the medical director will then influence some of the corporate value. If you're selling that, say, selling a healthcare business to private equity or someone who isn't a licensed professional. Additional points. And then, the audit, stark compliance you have here. And I add to that, Florida has an even broader, in some respects, physician self-referral law than the federal law, where the federal law only applies to federally paid programs. Florida's law applies to almost any designated health services, regardless of who the payer is. And there's some exceptions to both the federal and the state, but something to be aware of. And if you think that there's a compliance risk, has that been something that you've experienced, or either from someone where you worked on one side or where there's an issue on the other side? I know that's been a factor, and at least in one case that I had that went to a mediation and an arbitration was this compliance issue, that perhaps the parties weren't acting in compliance and therefore didn't want all their dirty laundry aired, which had an effect on what the whole value was.
Yeah, I haven't seen that myself, but it's something that, in their procedures, their operating manuals and the procedure manuals, we want to make sure that the entity has a hotline. It may not ever be used, but you want to make sure they have it. And are they doing the best they can to not get in a position where they're subject to a Stark Law compliance claim?
Yeah, that can really tank the value of a business. Although again, you have more flexibility. There may be issues that you do not want to deal with in the court context where the court file becomes a public record. But in mediation, and it's another reason why I often suggest with a lot of folks in healthcare that not because of the compliance issues, but just the confidentiality and privacy that are available, not only in mediation, but also in arbitration. It's not public. You can agree to a blanket order at the beginning of the case to keep everything in the arbitration confidential. Of course, everything in the mediation is confidential. And if you don't settle, sometimes you use that information afterwards. Sometimes you don't in the discovery process, but you don't have any obligation to disclose it or right to use it unless you've gotten specific permission outside of the mediation. So one more advantage there for why it makes sense to deal with these issues in a confidential setting. I think I'm going to head here. Just another compliance issue. Florida the Patient Brokering Act in Florida. Similar, we have kickback laws for state and federal. Essentially, you can't give somebody some type of remuneration for sending patients or sending clients your way in many healthcare practices. If you have a practice that's at risk for violating any of these laws, or if they've been sued either civilly or sued by a federal agency for violating any of these laws, that's going to obviously have a negative impact on the value. Somebody asks a question here: is Stark law a federal or state law? So Stark is federal. It's named after the congressman who developed the law, and it's a self-referral law that applies to payments in generally in Medicare, Medicaid, TRICARE, federally paid third-party payers for healthcare services. If you are a physician, and we put the elements up there, but essentially the physician cannot refer patients to another business, another practice for, say, maybe for X-ray or MRI or lab work, where the physician has a direct or indirect financial relationship. And that's been interpreted pretty broadly. So indirect financial relationship doesn't mean the physician has to own that other business, but if the physician's brother or wife or son, daughter has any other type of business, and it doesn't necessarily have to be healthcare. If the physician refers for, there are a list of designated healthcare services, but it could be for equipment. Sometimes DME is a big issue. That's all at the federal level. At the state level, not every state has an analogous state statute, but Florida does, and we've got our own Florida, the self-referral law that applies more broadly, applies to any payments, not just your Medicare, Medicaid payments. But there are some differences, so that just because something's excluded or not permissible under Stark doesn't mean, or pardon me, just because something would violate Stark if it was a federal payment, it doesn't mean that it'll violate the Florida self-referral law. I hope that's helpful. If you have more questions on that, let me know. I think I did an article on this a few months ago. So cybersecurity is a huge issue, workforce in place. And then we'll talk about, let me see, and I would look at our time here, talk about personal goodwill versus corporate goodwill. So I'm going to jump ahead to our slide on the personal goodwill there, and then this is a good slide too. Is the practice litigation prone? Would that impact your valuation if you had a business that was more prone to litigation than some that aren't? How would that play into the valuation factor?
Well, it would. We always ask if there's any contingent liabilities that we need to know of, or contingent assets for that matter. But yeah, it does make a difference. It's the stability of the cash flows. Are these cash flows recurring, or are they going to be consumed by payouts for wrongdoing? So I want to know what kind of cash flows are available to the bottom line, to the owners.
And where does that come into the report? Would that be in the corporate goodwill, the company goodwill, a business that's at higher?
It might be a company specific risk. If they're prone to litigation, they have a lot of ongoing issues in that area. Or we'll address it in the actual cash flow. We'll make an adjustment to cash flows, either up or down. So we, in the valuation world, we normalize cash flows to probably exclude a one-time payoff for a litigation claim, for example, fraud or something like that. But we want to look at the underlying components of how that expense came to be.
No one wants to take ownership of a business that could end up in one or more lawsuits or some type of regulatory issues, being attacked by federal regulators, et cetera.
Yeah. So it's good to look back, through the history, the financial history of the firm, and see if there's any unusual payouts of that nature. Yeah, absolutely.
Now, how about the personal goodwill? How does a key man or a key person type analysis impact a business valuation?
Well, it's a really big deal. It goes all the way back in the tax courts, back to the 1940s. We have some case law outlined here on one of the upcoming slides, but it's a really big component of not only the play for tax reasons, but just in what am I selling? I said earlier on in this seminar that I sent out an interview worksheet to the business owner, and I want to ask them, what do they do every day? Are you really critical to the daily cash flows, or are you able to, travel at will and stay away from the company and let the cash flows come in? A lot of owners, they enjoy working, but I cannot sell the owner unless they've signed a non-compete with the company or an employment agreement on the buy side. So I like this slide here, point 11.4. Doctor, there's kind of a summertime Christmas analogy here, but the Dr. Claus, it's very obvious who's being marketed here. The doctor, him or herself, is the owner of this company. And in the second part there, we have Dr. Claus's ophthalmology group, which broadens the scope a little bit. So there's more operators involved than just Dr. Claus. There's maybe several other, or one or two other doctors. And there's more than likely a component non-physician provider staff that is generating revenues. And then in the third example, we have the North Pole Ophthalmology Group, which is not specific to any doctor at all. So that gives me the opportunity to kind of get into the business goodwill component. So I just wanted to reiterate that, it's great to have a healthcare provider delivering services on a daily basis. But if that healthcare provider can have non-physician providers bringing in cash revenue, then there's something I could sell. So we get back into the patient list, the workforce in place, the website presence, and the reason people are coming to this facility. So if it's for example, if you have a, emergency care facility, I'm not really too concerned who the doctor is. I just want to get fixed. And so that's an opportunity for private equity to come in and buy up your local urgent care center, for example.
Now, in the dispute context, like in a mediation, this is a concept I think that's often lost on parties, and even sometimes some lawyers who don't deal with the issue a lot, because when we look at a regular business sale, or if somebody's buying an interest in a business, it'll often be coupled with a non-compete. So if I'm going to buy a physician practice, obviously, if the doctor's not going to stay with the practice, who's got the relationship with the patients, we want the doctor to sign a non-compete. And in the employment context, non-competes, we can go up to 2 years that don't violate the presumption of being unreasonable. But in the connection with a sale, we can go up to 5 years. But in the breakup context, we often have, I've seen oftentimes situations where the parties want a full value for their part of the business to get bought out, or they want to buy the business from the other partner, but they don't want to, they want the other partner not to compete, but they don't want to pay for that. And really, I think the value of what you pay for the non-compete really gives us a good starting point for the value of that personal goodwill. You agree with that?
Absolutely. And to your point, what we'll do in that case is we'll value the company in its entirety, with and without certain key persons, right? So we'll determine what, if they all were on board, here's what kind of revenue that's going to come in, more than likely. And if we carve out that person and the associated cash flows, obviously there's going to be a different valuation result.
And I would add too that not only using the experts to help explain this concept, but for parties, again, it may just be that they haven't dealt with the issue previously. It's a newer concept. This is, in my view, where the role of the mediator can come in to be helpful for the parties, to explain, look, the other side's not trying to pull the wool over your eyes. They're not trying to pull a fast one. This is quite common, and it's a regular practice, and you have to look at the value of a business interest or value of some type of interest, especially if it's in dispute, both from the context of if you're just buying it outright with no strings attached, or if you're attaching strings such as restrictive covenants, non-competes, etc. It's going to have a different value, and a skilled mediator should be able to help convey that point to the other side, and at least help with that flow of information and education process, so that you keep the conversation going.
Absolutely. Those are really good points.
See, this has gone fast. We should almost do this as like a two-part. You have a lot of information.
We're only halfway through the slides.
Well, we knew that we knew that the slides were going to be more, but hopefully we're able to provide this information. It looks like a couple folks may not have gotten the materials. I will, if you send me an email, we're at about 12:57. Tom, what are the most important takeaway points maybe that we want to leave the folks with that we haven't touched on, or it's something that you want to revisit and talk about?
Well, I just wanted to mention again the concept of keeping an open mind. So when you're going into a contract negotiation or any kind of mediation, you want to just maybe make the statement that I could be wrong here. Help me understand your point of view, and it really opens up the other side to we're not just in a battle here. I really want to know what you're thinking, and if you can articulate your points, then that's great. If you can't articulate your points after I've asked for them, then that's a win for me. So I really enjoyed this time with you, Eric, and with everybody paying attention. Is there any other comments here, or cannot get the materials?
We'll get the materials out to folks. If you have follow-up questions, I like, Tom, how you put, you gave a couple website links. You also gave us some cases. You mentioned hiring. I had this slide up here. Consider hiring somebody to review an expert report on the other side. I think that's essential. If the other side has an expert, you at least need someone you can consult with and trust to help you at least interpret the information and find flaws in the information. And a good lawyer, a lawyer with experience in this won't try to figure it out themselves. They'll realize that our knowledge is limited. We're legal professionals, and we rely on folks like you, Tom, and to parse through complicated information and make it understandable. For our audience, here's Tom's information, and I'll have it on the last slide here. Few cases. Thank you for providing these, Tom. These are on the key person issue. There's also I've done some research on this myself in Florida, and I know that there are some Florida cases, and there is a discussion about the personal goodwill and what the value of that is in connection with a business breakup. It often happens in a divorce context. I've done some divorces where we have business valuation issues. With that, if there's any other questions, we are at 12:59. We have a credit available for the seminar. Tom, this is fantastic stuff. I appreciate it very much.
Great to be with you.
And maybe we'll come back and do something similar in the next few months. For the folks here on the webinar, we'll go ahead and send out an email for folks so you can get those materials, make sure that you have them. And with that, we are at 1 p.m. And if there's no further questions, I suppose we'll call it a day. Thank you, everybody.
Thanks, everybody.
Thank you, Tom Gillmore, again. You have contact information for both Tom and Eric up on your screen if you need it. And with that, we will bid adieu until next month. Have a great rest of your day, everybody. Bye-bye.
Great day, everybody. Thank you.